Okay. Baruch atah Adonai Eloheinu melech haolam asher kedishanu b'mitzvotav v'tzivanu l'suk b'divrei Torah. Baruch na Adonai Eloheinu et divrei Toratcha b'fidim v'yevcha beit Yisrael. ונהיה אנחנו וצאצאינו וצאצאיך בית ישראל כולנו יודעי שמך ולומדי תורתך לשמה. ברוך אתה אדוני מלמד תורה לעמו ישראל.
אמן.
ברוך אתה אדוני אלוהינו מלך העולם אשר ברך בנו מכל עמים ונתן לנו את תורתו. ברוך אתה.
Amen.
Amen.
Okay, guys, we're going to start with the Mishnah Brura. We're on 179. Yay, we've spent ages on 178. We're now on 179. Okay, it's funny though, because both the Mishnah Brura and the Shulchan Aruch have the same sections. In the Mishnah Brura, we're on section 8 and 9, and the Shulchan Aruch section 3. It was obviously done like that on purpose, because they had halachic links to each other. So we discussed yesterday what would constitute a separation between eating. In other words, what constitutes a break? And there were two things. There was intention and there was action that denoted that intention. So yesterday, what did we discuss, guys? Just two words. What was it about separation? Correct, Kevin. Ma'im achronim. Now we're going to deal with a different issue, the same issue, but a slightly different aspect. Say, Kevin, you pick up the cup of wine to bench with. Once you pick up the cup to bench with, it's the same as ma'im achronim. So some people that don't have a culture of ma'im achronim, if you should pick up the final cup to do, before you do Birkat Hamazon, people pick up a wine cup. In that case, that's a hefsek, that's a separation. So as with ma'im achronim, you mustn't do any activity or speak until the benching occurs, and that is objectively considered the end of the meal. So there's other more subjective interruptions. So Gavin, just say you turn around and say the words, let's bench, okay? If we listen to you and we don't ignore you, that's considered a separation where we've all stopped eating. If we ignore you, you can stop eating, and that's the end of your intention, but not the end of ours. When Gavin really wants to convince us, he'll turn around and says, please bring the cup for benching. And he starts to sing Shir Malot. That would be probably a much more influential statement. Why? Because it's forcing other people to participate. Does that make sense? As opposed to a suggestion, let's bench. So you bring the cup for benching. Or you bring up this Mirot book, and you start singing Shir Malot. Okay, that was just a joking guess, but apparently here it's very serious. If a person genuinely decided to bench and end the meal, it's considered an end to the meal. So in different homes we have different outcomes according to the halacha, whether you're doing ma'im achronim or not. So if it's a Yekka family, German Jews who live by the clock and are more formal, then it's very likely that them saying, let's bench, or I'm done, or bringing the books, or even deciding to do it without announcing it is the end of the meal. But others, such as Hasidic or South Africans, may just be saying, but they'll bring out tea and cake for another hour before actually benching. This is an ex-South African writing article. Okay, so if a person is basically finished breakfast with toast and tea, and then he gets a long, important business call, which could potentially be lucrative, when he stops to take the call, it is highly likely to have decided in his mind to end the meal. So it's less important what the person did, but rather did the person actually decide in his intention to stop the meal? Okay, so we're going to end off on this note. The halacha in such cases where the person has indeed decided not to eat or drink further depends on the drinking. He must make a new bracha, drinking something that is not there to quench his thirst, such as like alcohol, etc. But if the drink is required just to wash down his food, it's considered eating, and it does not require another bracha. Does that make sense? So if it's part of if your custom is to drink normal liquids, and the benching will cover it. even though you are drinking, as long as it's not hard liquor. Okay, because nobody drinks hard liquor with your food unless you're an alcoholic. Right, as far as eating is concerned, you shouldn't eat anything else. If you have to do anything else, you have to make, it's as if the meal never stopped. In other words, at the point where you continue eating, even in, it's a continuation of the food. All right, guys, this is by Rabbi Daniel Brody, Rabbi Gary Brody's brother. I hope that's been informative. I was joking with Shira Malak, but they were being serious. All right, guys, thank you very much. We're going to start the daf now. We're just going to do we're on 4B1, 14B1. And I'm just going to summarize and test you guys, okay? But before I test you guys, I need you to ask you one or two questions. Let me just share the screen. Okay. All right. So the Mishnah, Mazel Tov, guys, we are the third Mishnah. So the Mishnah states, the determination of payment of damages is made by monetary appraisal. One pays with items worth money. This halacha applied before a court, and it is based upon the testimony of witnesses who are free men. In other words, men who are not Canaanite slaves, and who are members of the covenant. For Jewish people and women are included in the halachot of damages in the same way as men. So what we're coming to see here is, does it mean with the halacha of damages in the same way as men, is that it's obvious. It would seem to me that if you damage the woman, she's entitled to claim just as a man would. But what we think trying to find out here is, if she caused the damage, is she as obligated as a man? And probably it's yes, but we can go through each statement properly. And both the injured party and the one liable for damage are involved in the payment. The Gemara will explicate each of these principles. Fine. I'm going to stop sharing the screen.
Damon?
Yeah?
So, 1 second, just a minute. So what happens if a non-Jew is involved?
Great question. We're going to unpack that sentence by sentence. That's exactly what we're going to do. So the first sentence we're going to unpack, it says payment is made by monetary assessment. Okay? So what we said yesterday is, we were quoting the Gemara who quoted Rav Yehuda, and the Mishnah is saying that this assessment of the amount to be collected should be made solely on the basis of the amount of money lost. Thus, we have learned from the general rule in the Mishnah that, which the rabbis taught explicitly in the following brisa. So, if a cow damaged a garment, or a garment damaged a cow, we do not say that the cow should go to the damaged party as restitution for the garment, regardless of the monetary value of the damage, nor do we say that the garment should go as restitution for the cow. Rather, we assess the damage according to its monetary value to determine the amount of restitution. So, Arthur mentioned something. Arthur, you made a mistake yesterday. You said, listen, if one is Tam and one is Muad, you pay the difference, but if they're both Muad, they cancel each other out, and if they're both Tam, they cancel each other out. That was what you proposed. And it's not true, because the Tam and Muad are secondary factors to work and see the leniencies. But the first thing that you do is you say, okay, if two articles damaged each other, in other words, two ox try to gore each other, what damage did each party sustain? And at that point, you can say, all right, what is the level of obligation of each of these animals now that we've determined the amount? Because we're bringing another factor. A leniency of Tam has two leniencies. What are they, Arthur?
The leniency of Tam is only half damages. That's the first leniency. I can't remember the second leniency. So,
okay.
Next.
Anybody?
Okay, so it's, yeah. Okay, so it's limited to the gufa of the body.
Excellent. So those are the two leniencies. But you can't work out leniencies until you've worked out what the amount owing is. That's the first step, is to see is to assess the damage of each party. Nothing cancels each other out. Everything is worked out exactly. So the Gemara is proposing 3 different scenarios here. The first scenario is when the garment damages the cow. How does that work? Is that the cow trips over it, slips, and breaks its leg. And they have to either allow for the injury to heal, which is going to cost a certain amount of zuz, or they have to shoot the animal because the animal can't recover from the fracture. They do that sometimes. And then obviously that animal is rendered useless. And then we take into account the animal's difference while alive and dead, and the person pays the balance of the value, and the damaged party keeps his own ox. You know, we've learned that. Now we're learning a case of what happens if an ox damages somebody's property, like a garment. It doesn't just mean that if I damaged your leather jacket, that you're entitled to my cow that far supersedes the value. And it doesn't mean that, for example, you see, this is where it gets a little bit complicated. Take a case, guys, of trampling. Is trampling a case of goring, or is it a case of regal or shame? What is it? Regal. So fine. So in the case where, for example, your ox in temper decided, Gavin, to kick or squat my fur coat. In that case, that is a case of what? Gavin? Squatting or kicking or whatever. What is that?
It's regal.
No,
Regal.
it's not. It's a tall dove of Keren. Correct, Kevin. The tall dove.
What's it called?
A tall dove of Keren. It's a...
I meant Keren. What did I say? Regal.
Yes.
Sorry, no, I meant Keren. I apologize. That's what I meant.
So that's exactly it. So the time factor would come into that, but not if it trampled on it. Why? Because if you trample on it, there is no half payment for shame or regal. So if your cow found my leather jacket tasty, you know, I must tell you something. No, my landlord had a goat in Sydenham. In the middle of Sydenham, they had 6 kids. So they bought a goat, and that goat ate clothing and everything. They're destructive animals. So that would be a case of shame. For some reason, there was gratification for the goat to try everything. So shame is that if it's a first offense, it doesn't matter. It's always muad. And the tordah of shame is always muad. In other words, if it's scratching to alleviate an itch, because shame is physical gratification. Regal is the normal way an animal moves. If it knocks over an object or tramples on it, that's full payment regal. So you've got to determine why the animal did it. So if there are no witnesses, you can only assume it's regal because you haven't seen the ox smacking it in temper. You can only assume it's a normal trampling. So that would be muad. Does that make sense? So,
yep.
That's ox damaging a garment. Garment damaging an ox is obviously if you left something in the public domain and the ox tripped over it, that would be a case of damaging the ox. Now, I'm going to ask Kevin a question. Kev?
Yeah.
Are you with me? I'm going to ask you a question.
Yeah, I'm just sitting there. Yes, go ahead. Yeah.
Okay. Now, many of the commentaries say there's 2 major factions of disagreement here. Some of the commentaries saying it's talking about a case of either a garment damages an ox or an ox damages a garment. In other words, they're 2 separate cases. Then your second point of argument is it's the same case. So while the garment was left there, the ox trampled on it, injured itself, and ruined the garment. So they both occurred simultaneously. Which is why yesterday I mentioned a case of Keren, because we only briefly touched on the fact of Keren, of 2 oxen that were charging at each other and attacked each other. Does that make sense? And in that case, what you do is you work out the damage of each animal. Is this animal tam? Is that muad? And an exact calculation is made to the relevant parties. Fine. So this is a case that many of the Meforshim say it could be a case one case, and there's an argument against it being one case and they're two separate cases. Either the garment tripped over the cow, or the cow trampled on the garment. Okay. Now, why can't it be one case? What do you think the logical argument is about it being one case?
Can I make a suggestion?
Please.
Maybe the garment is like a board. If it's in the public domain, it becomes like board. Maybe an ox injures itself on it.
Okay, so follow that line of thinking. Okay, so in a board, what does that mean? You're onto something. You've touched the point. Getting there.
In terms of liability, or I don't see, I'd say for the pit, if the ox falls into a pit in the public domain, as long as it doesn't die, only the things the accessories that it carries, the products on it's only the owners, the damage is only liable for that, as far as I can recall.
Okay, so Kevin,
it's in the public domain.
Wait, one of the points Kevin brought up is what happens if it was a donkey, and the donkey was carrying a load, and the garment was left in the public domain, and the animal tripped on it and fell and damaged things that were hidden, or damaged things that utensils, etc., etc. What would happen to those things? Does it work the same as a pit?
That was my question, yeah.
I would say yes. I would say it works the same way because it's an obstacle.
Correct.
And an obstacle is a pit.
Correct.
So therefore, the utensils
And
you're not
stationary.
obligated. You're only obligated for the damage of the donkey.
No. So we learned. I don't want to go through that whole share again, but you guys need to do a bit of chazorah in terms of, according to Rav Yehuda's opinion versus the rabbis, the utensils, things hidden in the sack, etc., etc. I don't want to go down memory lane, but all of the factors that would apply, in principle, Kevin is correct, to a pit would apply in this case. It's a torda. It would be considered a torda of pit, one of the subcategories of pit. Well done.
And also it's also mu'ad by default.
It is more by default. That's absolutely correct.
I left that out. Sorry, I thought I got it right. I'm trying to explain a pit. What did I say wrong?
I'll tell you. You said it. You're only responsible for the actual animal that gets injured in the pit. Okay? And there are circumstances about what is hidden. There's circumstances about, for example, utensils. There's opinions of the rabbi versus Rabbi Yehuda. So the only point I'm trying to say to you, Gavin, is whatever would apply to a pit applies in this case to that particular garment, but it's not that you only pay for the animal. Whatever the halachas are to the pit, which we already...
No, I know there are opinions that do say that the utensils, that you're obligated for the utensils and hidden objects. But I'm saying, I think the rabbis, from my understanding, said no.
So we'll go through that, but the point of it is, as long as you understand, Kabb, which you do, is that whatever you're obligated in the pit, which is being the av here, you obligated for the torda in the same way. That's what I'm saying.
Correct.
Good.
Correct. No, I do understand that. Thank you.
There is another point. They can't occur at the same time. Let me tell you why. There's a practical reason. You can have this as a theoretical argument to determine costings. But let me tell you something. If you have in the public domain, Arthur?
Yeah.
Are you
have in a public domain? I'm listening. I was just looking at something that just came up.
Okay. So what would happen is this. There's a garment in the public domain, and the animal would trample upon it, and then the animal would be injured by the garment of trampling on. There's a problem. What's the problem? Are you responsible for regal in the public domain? Regal, not the board.
Not normally.
No.
No.
No, not
It's
normally.
Normal action of the ox, natural action of the ox.
But this is not regal because that's an obstacle.
No, you are, because we're saying a case here as follows: is say afterwards two people come to court, okay, and they're saying the person is saying, look, it's fair enough. It's fair enough that you did damage to me and I did damage to you, but the damages aren't equal, and the court's going to work it out, and whoever owes the balance of the money must pay. My stuff was damaged, your stuff was damaged. Okay, clear. It goes to court. First, so this one is saying you shouldn't have left your garment in the way, and the person is saying, well, your ox destroyed my garment, you also owe me. They can't get it right by arguing in this. All right, let's take this to Beis Din, let's sort it out. There's a problem. Why can't they occur? Because there's only two or three places, there's only two places that can occur. Either it's in the public domain or private domain. If there's a public domain, you're not responsible to pay for regal, because what is that person's object doing in the public domain? It's an obstacle, Gavin, exactly as you said. So why should I pay you for my ox trampling on your garment? But what was it doing there? You say I ruined your garment. You say that the cost of your garment that I ruined has to be deducted off what you owe me for the cow. Does that make sense? That's where we go to court. You say, fine, I accept your cow.
But that's why I said this is not a case of regal.
No, Kevin, we were talking about a different issue before. I need you to hear me. The case we were speaking about before was a case of trampling, because one of the Torah of Keren, it would have to be determined if the animal was trampling on it in temper, or if it was a case of just walking on it, and you would need witnesses. Because if an animal is squatting or kicking or trampling, it's a Torah of Keren, and it has two ramifications. So, Gavin, what I'm saying is one of the things that have to be determined in the court, let me tell you what it is I'd have to say to you, I could turn around to you and say, listen, this ox damaged you, okay? It was an act, it lost its temper and it trampled on your stuff, and it's been misbehaving. I owe you time, I owe you half damages. The ox hasn't done this act of Keren before, the Torah. It hasn't done it before, so I don't owe you full damages. Does that make sense? So it would have to be determined. The default position is it's regal, unless there are witnesses that show the ox lost its temper. Because it would naturally, what's the most common damage? Regal, the way the animal naturally works.
No, agreed.
Clear. But if the witness turn around and say, listen, this ox actually lost its temper, it's tongue damages, you couldn't argue. It'd say maybe that's why, because the ox is going like that. Kev, you wanted to ask something?
No, I'm just saying, how do they know if ox
the default position
working in its normal course of walking?
So that's the default.
It goes up like this and like
correct. So the default position is it would always be regular, because that's the most common way that an animal moves. But unless there are witnesses that say this thing had been like misbehaving all day. Does that make sense? It have to be witnesses to the contrary, because regal is the default position. But there's another point I want to get to you, is that say that your garment damaged my ox and my ox damaged your garment, and you're saying, fine, there's cost for the ox, there's cost for the garment, let's work them out exactly, let's take this to Beis Din, and whoever owes the difference owes the difference. You know, could be a Dischem special cheap rain jacket, or it could be a fur coat. So that would be determined. This is the problem. If you want to say it's one case and not a case where the garment damaged the ox or the ox damaged the garment, this can't really occur in practical terms. Why? Because if you left it in the public domain, you exempt for regal damage in the public domain. I could turn around to you, Arthur, and say, listen, you say you damaged my fur coat. I'd say, what is your fur coat doing in the public domain? It not only ended up being a pit to damage my ox, in which you owe me damages, but regal isn't obligated in the public domain, because we just learned in the last stuff, in an area where animals are allowed, regal and shane are exempt in the public domain. So not only do I not owe you anything, you owe me. Okay? So that's the first problem, to say it's one case. Then the second problem is as follows. Say it happened, Arthur, in your place, and my ox tripped on your garment, damaged your garment, and it broke its leg, and I had to shoot it. And I say, listen, I owe you 20 Rand for the garment, but you throw only I owe you 20 zuz for the garment, but you owe me 300 zuz for the ox. You'd say, I'm not paying you 300 zuz. I say, let's go to Beis Din. So then Arthur takes me to Beis Din, and he says to me, firstly, he says, you don't owe me for the, I'm not paying you for the garment. I'm not paying you for the ox, but you pay me for the garment. I'd say, why won't you pay me the ox? What are you doing on my property? I never gave you permission. It's a good point, right? Arthur would win the case. I'm not allowed to be on his property. So, where would be a case where both of those incidents will occur together? That's why there's two different opinions on this issue. The Meforshim turn around and say, okay, it's talking about one case where the garment damages the ox and the ox damages the garment. And then there's another case which turning around and say, listen, so in other words, the one argument is that two separate cases. Either the garment damages the ox. Separate case, the ox damages the garment. That's one point, as that a separate activity. The other one is that they happened simultaneously. And we say, all right, if you want to say that two ox have gored each other, and we need to work out the difference to illustrate this principle, I understand. Let's work out exact monetary compensation. Let's not be vague. Understand the principle. But you cannot use it with a garment and an ox. Because in a public area, you're exempt for regal. And in a private area, if my ox tripped on Arthur's obstacle in his property, what is my ox doing there? I don't owe him anything. In fact, I owe him for the garment. He doesn't owe me for the ox. So we can't see a practical issue about how this would be achieved. Does that make sense, guys?
Yeah.
Okay. All right, good. Gav, you okay? You look a little bored.
No, I'm not bored at all.
And James?
I'm just trying to keep my head up.
The good thing with ox, if you have to shoot it, I can then take its hide and make you a garment for you.
I didn't think of that. All right. So, the person that brought up this discussion is the Bach. This is the Bach's reading of Rashi, that it's two separate cases. Rambam and Rabbeinu Tam says it's one case, but this is the issue that the Bach is saying with regards to having it as one case, the issue I'm bringing up now. Are you with me? He's saying, okay, if you just want to discuss the theory of it, great. Because you want to say that everything's calculated, but how does it work in this practical term? So I thought it was an interesting commentary. Now we're discussing the next part, is payment is with something with money. Okay. Payment is now it doesn't use the word something in the Gemara. It has in brackets the word something, because if we say payment is worth money, it doesn't make sense. The word is shaveh kesef, which is something that's worth money. So what does the Mishnah come to mean by this? So the Brisa explains, for the rabbis taught in the Brisa, when the Mishnah says that payment is made with something worth money, it teaches that the court does not involve itself with anything but real property. Okay. So what are we saying here, guys? I'm testing you. What have I just said?
Just repeat that, please.
No problem. That's exactly what I wanted to see. You guys are concentrating.
Yeah.
Okay. And don't worry, guys. I'll end off. I will edit out all the musa I gave you for falling asleep in my shiur when I didn't entertain you enough. I should have set myself a light with kerosene and juggled balls for you. What can I tell you? So that was my fault. But I'll edit.
Coffee would have helped.
Coffee would have helped. Sorry, but Arthur, I'll take that out. I've haven't had enough sleep. Okay. So this is what, Kevin, I'm going to repeat it. The rabbis taught in a brisa, when the Mishnah says that payment is made with something worth money,
Okay, I know this one.
it teaches that the court does not involve itself with anything but real property, because the Mishnah starts off saying, payment is made with monetary assessment. We just said that it's worked out exactly the damage by both parties, with something worth money. Okay, so we want to know what the Mishnah means by with something worth money. And what it's saying is the rabbis taught in a brisa that the court does not involve itself with anything but real property when it comes to collecting for something worth money. Now, let's just discuss this, because there should be a question you guys have. In other words, it's saying the court will not collect from the damager or the creditor unless he has real estate from which to collect. That's according to Rashi. Now, this should actually worry you.
Well, it contradicts the opening statement where it says anything worth money.
Exactly. We learned in the case, Kevin, you have got a bit of memory there, and it's impressive. If you look at Exodus chapter 21, verse 34, when we looked at the case of an animal that fell in the pit, it said to pay something to be returned like money. Remember when we used that phrase? Okay, and what did it basically mean? It meant that you can pay with anything that you could convert to cash, even bran, as long as you were paid with that sort of value. That's what we were dealing with. Now, this seems to have a contradiction. What do you mean you can only pay with real estate? What's it talking about? We learned that you could even pay with bran. Does that make sense? Gavin, well done. Okay.
No, pleasure. It goes back to the pit story, yeah.
So fine. I had this discussion with Rabbi Cohen because it bothered me too, and Rabbi Cohen explained to me one or two things here that made it quite clear. He's got a vast of knowledge. You must remember that Rabbi Cohen knows the whole of Shas, and apart from knowing the whole of Shas, he knows Bava, Kamma backwards. So this is what it's saying. Is the first point you've got to bear in mind is that if somebody damages your property, I've only got 2 minutes left, so guys, I need to just finish this part. If somebody damages your property, okay, at a case where you never asked for them to damage your property, obviously first thing you want is cash. If you can't have that, you would like choice property of highest grade to be able to sell it quickly to recover your losses for the damage. That's first price. But what happens if the guy doesn't have property, etc.? You just want your money back. So at that point, you're going to take anything worth that value so you can sell it and convert it to cash. This is a case where we're mainly talking about loaning somebody money, so that a creditor loans a debtor money. Now, just use your brains. Even though you meant to help your brother, if the guy has got no assets whatsoever, it's very unlikely you're going to get the money back. Okay? Because why would you grant a loan without property? Why? Okay, let me just tell you what, because at the end of the day, what we are saying is property itself has a guarantee. Okay? What do we mean it has a guarantee? It can't move anywhere. You can't sell it. It can't break down. You can't sell it under somebody's nose or move it. It's stationary. You can change title deeds, but the property isn't going to. If the court turns around where you sold the property, where you owe me money, and you've sold it to somebody else, it doesn't matter. It really, really doesn't matter. What it means in that case is the court can get you to return it to me, and then that seller has to recompensate the buyer. But if it's immovable, you can hide it, you can sell it, you can't trace it. How? So there's a difference between damages and creditors. Just bear in mind. Now, the first thing that the bank does want to do is attach real assets, because real assets are of value.